Welcome to our third class. We're going to start discussing, actual English speaking law, so actual common law, and we're going to start off with English constitutional law. It's important to learn this before we move on to American law because really this sort of influences all of law that happens, specifically constitutional interpretation is very much influenced by English constitutional law before the American Constitution. So we're talking about the Bill of Rights of England or the Magna Carta, and we'll analyze this. So the United Kingdom, and you've probably heard this in law school, does not have a written constitution. To me, this unwritten constitution is hard to even call it a constitution, but the most legal scholars refer to it as an unwritten constitution. So it is something that has evolved over several centuries, and there's a lot of pieces of legislation that are a part of this constitution, including, beginning with the Magna Carta. And the Magna Carta, basically, early 13th century, you're thinking about King John Lackland. His nobles were very unsatisfied with his leadership, and they basically, because he was levying excessive taxes to pay for some wars, and he was acting in an arbitrary manner. So basically, English nobility said, well, you can stay on the throne, but you have to sign this document basically stating that you will give us certain rights and privileges. So really, it was a treaty between the English nobility and the king. It wasn't really meant to apply to all the citizens, because all the citizens were basically servants, and it was a period of, it was the medieval times, so it was vassalage. But over time, it expanded to basically cover all human beings in the United Kingdom. Basically, you had the Magna Carta is really more of a peace treaty than some sort of early constitutionist, basically. And only certain aspects of it remain in effect, and we're going to go over it now. The first clause, which established the Church of England as an independent body. This is still the Catholic Church. The rift between the Catholic Church and the English Church would not happen until the 16th century, but it was still sort of an independent body. And today, this is sort of used as a way to assert that religious freedom exists in the UK, even though there's still this institutional role of the Church of England, because the monarch is the leader of the Church of England. So really, there's no separation of church and state, but there is religious freedom. Yeah, basically, it's still the Catholic Church, but with some autonomy, especially with regards to the king, which begins to show, I think, signs of the England drifting away from continental Europe. Because in continental Europe, in the medieval period, and especially in the early modern period, the 16th and 17th century, they would develop the idea of the monarch being chosen by God, the absolute monarchy. And in England, because of the Magna Carta, that even though there was a period of absolute monarchy in England, especially with the Tudor dynasty, that never took off as much. So already by the 17th century, they were talking about parliamentary supremacy, and the king is not the king's authority is not unlimited. And we're going to see this with the English Civil War and the Glorious Revolution. So basically, Clause 13, this is for the City of London. And the City of London, if you're not familiar with that term, is basically a little borough in the center of London, which is not part of the London itself, but is independent. It's an independent entity called the City of London. And it has its own really interesting form of government with aldermen. And it basically functions as a tax haven within London. And it's where most financial institutions in London are located. Also around the world. After Brexit, the importance of London as a financial center diminished a little bit, but it's still a lot of companies are headquartered in the City of London, especially financial institutions. Clause 39, very, very important. Basically, the right to a fair trial and the idea of due process in a court of law. So no arbitrary imprisonment. So this is a limitation to the king's authority. And this is basically establishing the idea of habeas corpus, no arbitrary arrests, due process, and eventually jury trials. This is here from the case of the Five Knights. This is right before the English Civil War, when they actually executed their own king, which is unthinkable for most Europeans at the time, because he was not respecting the Magna Carta, and because he was detaining people in an arbitrary manner to sort of force them to pay more taxes. And this is what happens to the Five Knights. So basically, the idea was always that the king had a limited authority. He wasn't all powerful. Then you had the Bill of Rights. Like I said, the 17th century, extremely turbulent time. You had the English Civil War. You had the Glorious Revolution. You had kings being beheaded. For a brief period, England was actually a republic. And the Bill of Rights, it came, it came sort of as a document to sort of, appease the public and give them even more rights and limit the power of the sovereign even more. So basically, it created a lot of rights that were actually replicated in the American Bill of Rights. We're going to go over that now. Basically, a lot of things that are in the American Bill of Rights actually come from the English Bill of Rights. Even things like the Second Amendment, other aspects of it, or the Eighth Amendment, those things are also in the English Bill of Rights. Parliamentary supremacy, extremely, extremely important. Basically, the foundation of England as a democracy, in England as a constitutional monarchy, and really what was something that completely differentiated England and common law system from continental Europe. Because at this time in continental Europe, absolute monarchies were in vogue. So throughout the 18th century, you had these absolute monarchies in France. Obviously, we know how that ended up. But at the time, the idea of the parliament being the supreme authority was really a huge innovation. And it's still, the case today, there isn't, this idea of, a judicial branch or an executive branch. Parliament is supreme. Obviously, technically, it governs with the consent of the king. But in effect, it's Parliament that calls the shots. And by Parliament, really today, in the United Kingdom, you mean the House of Commons. The House of Lords is a diminished entity, it doesn't have a lot of power. And really, it's the House of Commons that calls the shots in the UK. Right to petition, this is reiterated in the First Amendment of the United States Constitution, as we'll see in the next class. Basically, you have the right to petition the government and the monarch for redress of grievances. So if you're not happy, you can call that into question. No standing army. This is a problem today. Because every number of years go by, and then the British Parliament has to pass a bill saying, we can have a standing army. The concern they had was because a lot of problems had been caused by warfare in the UK, and also by the king levying taxes to pay for his standing army. But today, you can't really have a country or a powerful country without a permanent standing army. So the British Parliament today just keeps renewing this permission without much thought. No taxation without parliamentary consent. So really, when you think about all the things that led to the American Revolution, they are rooted in the English Bill of Rights. And there was this idea that they were Englishmen and that they had rights that were not being respected by the English monarchy in the 13 colonies. And for instance, no excessive bail or cruel and unusual punishment. This was basically repeated in the American Bill of Rights. Regular elections, also revolutionary. Really, you have to, when you think about the American Revolution, you really have to view it as a continuation, I think, of this tradition in English law of having these things, which were very innovative and groundbreaking at the time. Today, I think both America and the UK are sort of falling behind in terms of representation, but at the time, they're really at the forefront of these things. Act of Union, before 1707, Scotland and England were separate countries completely. They weren't ruled by the same monarchy, they didn't have the same rules. And what happened before this is that Scotland had tried to have its own colonies in Central America, and that went very bad, and they lost a lot of money. So much money that they had to join forces with the UK in order to retain some stability. And ultimately that led to the United Kingdom being created, because before that it was just England. Basically, that had happened. You had in the 17th century, like I said, there was a lot of back and forth between England and Scotland, but it was only on 1707 that they actually became one United Kingdom, one sole country. And Wales had already been part of the England way before that. You had the conquest of Wales. This is a separate historical matter, but this joined, basically England and Wales with Scotland, and Ireland at this point was still being colonized by the British and by the English. So it was not really viewed in equal footing with the rest of the United Kingdom. Right, so the Act of Union. It's interesting because it's around this time, the last time that the British monarchy refused to grant royal assent to a bill. Basically, every bill that goes through British Parliament has to be agreed on by the monarch, and you call that royal assent. Except, because there's this idea that the British monarchy is supposed to be ceremonial, it's not supposed to wield political power over Parliament, the monarch has never refused consent in the past 300 years or so. So it was around this time, the last time the bill did not get royal assent. After that, assent was always given, and you had effective control of government by Parliament. Also, with the Act of Union, England became much more powerful and really began colonizing the whole globe. It already had colonies at this point, but it began having many more colonies after this. Another aspect of English law that you have to remember is that unlike the American Constitution, which from the very beginning mentioned slavery and protected slavery, the English documents, founding documents, did not really talk about slavery. It was sort of, a gray area in terms of law, if it was allowed or not. And this is what led to the things that we're going to see here. The Somerset versus Stuart case in 1772. Basically, a man was brought to England and he was being forced to go on a ship as a slave. And he was like, well, don't I have these rights from the English Bill of Rights and from the Magna Carta? Because, like I said, there was no express provision allowing slavery to exist. So he questioned the idea of slavery in the United Kingdom via the Magna Carta and the English Bill of Rights. And he was successful basically in eliminating slavery within the United Kingdom, but not in the British Empire. So the case was brought to the court. This is possibly one of the first cases that we're going to read. But it's interesting to think how this happened right before the American Revolution. And I was not able to find any evidence to support this, but to me, it seems like there might be some connection with the idea of protecting slavery through the American Revolution, even though really historically most people do agree that it's more about taxes. But you can see this is all happening around the same time. Basically, England, even though they participated in the slave trade for centuries and they helped, institute slavery in the Americas, there was a significant abolitionist movement in England at the time, in the UK at the time, and this basically helped lead the way to that. There was this idea, because the lawyers for the slave owners who were trying to send this man to be a slave were basically arguing that this was continuation of a feudal law, but the courts rejected that and basically said, well, there can be no slavery in the United Kingdom, but, well, they didn't expressly say that, but that was more or less how it was interpreted, that no slavery would exist in the United Kingdom itself, but they didn't say anything about the British Empire. Basically said, a master could not seize a slave in England and detain him preparatory to sending him out of the realm to be sold. It also ruled that habeas corpus was a constitutional right. So yeah, he didn't really talk about the idea of slavery too much. He just said that this particular case was a violation of the laws of the UK, and over time that came to be interpreted as there can be no slavery in the United Kingdom itself. So the ruling not abolished slavery in the British colonies or outlawed the slave trade. However, it did establish that people brought to England could not be forcibly removed and sold elsewhere. Basically, because of this protection, this effectively ended slavery in the UK, in the British Isles, because if you cannot control these people in the British Isles, then you cannot have them as your slaves. So it was a symbolic victory, and it paved the way for a big abolitionist movement, which was in the following decades spearheaded by Britain. We learned about the Bill Aberdeen. They dedicated a lot of resources to fighting the slave trade, which they had established basically, but they did prevent the slave trade beginning, in the mid-19th century from continuing, and they had a big role in abolishing slavery, even though they also had a big role in creating the idea of the slave trade. The Great Reform Act, so basically representation to people. We're talking here about rotten boroughs, and there have always been elections, especially because the 1688 Bill of Rights had mandated elections to happen regularly. Who could vote was a problem, because it was basically mostly just, people who own property, obviously only men. White men, there weren't really any significant minorities at the time in the UK. Mostly, white property owning men, Protestant men, not Catholics. Obviously, this was a huge limitation on who could and could not vote. Another problem that existed was the rotten boroughs. And there's a story about a hill which used to have a castle in the medieval period in the UK, which until the 19th century, that hill, which was uninhabited, had no people living in it, was represented by 2 people in Parliament. So that's the idea of rotten borough, these old medieval towns with almost no population that had big representation in Parliament, and that obviously made it an extremely flawed democracy. Honestly, it's hard to even call it a democracy, but this was a big expansion of who was allowed to vote. It did not expand the right to vote to women, but it did expand the right to vote to other men. Basically, redistributing seats, giving the seats to the big industrial towns in the aftermath of the Industrial Revolution, and taking it away from rotten boroughs. Expanding voter enfranchisement, so being enfranchised or disenfranchised in English, just having the ability to vote and to participate politically. and that was expanded to mostly to more people, but still a lot of people could not vote. Even men, a lot of working class men were still excluded. They standardized voting qualifications because this seems to be a tradition of common law of having very complicated voting regulations, usually with the intent of having fewer people vote. So obviously it did not achieve universal suffrage, both because it did nothing to improve voting rights for women, and also because it didn't give universal suffrage to adult men either. Parliament Act of 1911, it's important to note here that the House of Lords, the upper chamber of the British Parliament, still had some influence. It has been an influence that has waned and decreased over the centuries, and today it's extremely small, and it was decreased even more in 1911, basically saying that the House of Lords could not veto legislation. It could basically, if the legislation passes the House of Commons 3 times, then the House of Lords has no power to stop it. So it's not like, the United States Congress and Senate. The House of Lords really is a very limited body. And the reason it's a limited body is because it used to be made up almost exclusively of members of nobility. So people did not view that as a legitimate governmental body. Today it still has seats reserved for nobility, but most of the people in the House of Lords are appointed by the Prime Minister, and they're lifelong nominees. It is something that inspire people to sort of criticize it, say, isn't this corruption that you can just appoint, people who donated money to you to have this lifelong paid government role in the House of Lords? And people do criticize it, and the House of Lords is very big because people keep getting appointed to it, and it's a lifelong appointment, no elections. So that's why it has almost no power, because it doesn't have the legitimacy of the House of Commons, which is actually an elected body. The Lords basically lost their control over finance bills, and they would eventually lose most forms of oversight that they had over the House of Commons. Today they're more of an advisory body when it comes to legislative matters. They give advice because they're not elected, so they're like, well, I think this. And usually the House of Commons does give that some consideration, but they don't really have veto power. Except if the House of Commons tries to prevent elections from happening, then the House of Lords could potentially veto that. So yeah, the supremacy of Parliament really means the supremacy of the House of Commons. That is the actual Parliament. The House of Lords is more of a historical remnant that today is more of an advisory body. It was stripped also of all of its judiciary prerogatives, which it used to have. It used to be the final appellate jurisdiction in the UK. Today that authority is vested in the UK Supreme Court, which was established in 2009, and not in the House of Lords itself. The People's Budget, I talked about this. Right after the Second World War, you had Clement Attlee, and basically he proposed a budget which dramatically increased welfare, and it established progressive income taxation. So it laid the foundation for government programs in the UK, which still exist today, more so than the United States. You have the NHS, which is a single-payer health system that the United States doesn't have and the UK does have. And it was the inspiration actually for our own healthcare system. So it's a pretty expansive healthcare system that was instituted by the People's Budget. Basically, in the 1940s and with the acts that happened in 1911, you had, the conservatives sort of being defeated, and especially, the nobility being defeated in British politics. Yeah, so basically supremacy of the House of Commons, relationship between the two houses of Parliament, basically, really instituting the House of Lords as a limited body with only more of an advisory role, much like the monarch. Representation of the People Act, this is the thing that finally gave women the right to vote, even though it was more restricted than men, and it also extended male franchise. So more men could vote, and also women could vote, not all women, and they had to be over 30, so it was still unfair, and it still took some time for real universal suffrage to come to the UK. Redrawing constituency boundaries, so the UK has the same first past the post system that the United States has. Basically, whoever wins the most votes in that constituency is going to be the member of Parliament. That is a problem still, which is why you have to keep redrawing them, because it has to be reflective of where people actually live. Yeah, so big change, but still not universal suffrage. And then you had the Human Rights Act of 1998, which was just a way of incorporating European law into British law, and it expanded more human rights to the British people. And today it's funny to think of this because the UK is not in the European Union anymore, but it's still it's still a signatory to the European Convention on Human Rights, and you have the European Court of Human Rights, and not to mention that the Human Rights Act is part of British law itself. So you can argue and use this in your favor in a British court. Basically, it was an idea of incorporating the European Convention on Human Rights into British law, which is why that was done. If a bill is found to be a violation of human rights, then a court can say, well, this is incompatible, and then send it back to Parliament. But like I said, because of parliamentary supremacy, the courts cannot strike down legislation. There is no judicial review. And when I say judicial review, what I mean is the idea of controle de constitucionalidade. So there is no judicial review in the UK. Parliament is supreme, but the courts can send something to Parliament and say, please change this. We think it's incompatible with our previous legislation and with the English Bill of Rights and the Human Rights Act. But still, it cannot strike down legislation. And basically, that is the framework of laws that exist in the UK today that people refer to as the English Constitution. It is a complicated matter, and honestly, it's something that is hard to even describe as an actual constitution. But legal scholars have, described it in this way. They say it's the unwritten constitution of England, and it's important to know it, especially in the context of interpreting the American Constitution. So I'll see you in the next class where we'll discuss the American Constitution.